Okay, gang. We still got folks coming in, but so we're still, there's about 6 or 8 of the students who are not here yet. But let's get started. So because we have to end up in time to get us over to our other old place for our section. So I want to get started. Let's do the few administrative things we need to do. The photographs. I asked you to bring photographs. Probably more than half of you forgot that, but it's just a limitation on my persuasiveness apparently. So that please bring a photograph in next time, so that we can put together a little chart, so I can get to know your names and stuff like that. Okay. It's not because I'm going to be calling on you and forcing you to embarrass yourself over something you didn't read or anything, but it's just I want to know who you are by name, so I can remember you guys. Okay. The second thing is anybody who doesn't yet have whatever this magic code is that you need to have to get at the e-commons and other things. Check with Toby. Toby has all of those things that you guys need. Okay, and for the long-time learners, they're posting videos of the class and stuff now on the Romero Institute .org website. Okay, and also on my website that the staff put together, this danielpsheehan.com. Yeah. Okay. So you got all the reading materials and all that for all of you who really want to dig into to these things. Okay. So that's some of the preliminary administrative things that we need to deal with. So the question for today is, what does all of this bad news that I've been sharing with you for the first few orientation periods here have to do with our American Constitution, more specifically with our Bill of Rights? And what does it have to do with philosophy in general, or more particularly with this natural law theory that's in philosophy? And thirdly, with this issue that I raised of genuine spirituality, as distinct from the type of established state-supported type of religion that is basically tendered to you during your first 21 years of kind of naivete. So what is all of this got to do that I've been sharing with you about these kind of inside stories about what's been going on really in the world behind the veil of these kind of pretenses? So what I figure is what I'll do is I want to briefly give you some idea of my experience as to how I sort of came upon this realization of the fundamental dichotomy between what we're all told and what is really going on behind the scenes, and how I came to understand the important role of our Bill of Rights and Constitution in being able to ideally take back control of our own government from these sort of corrupted, corporate-dominated politicians and government personnel and the corrupted practices and policies that are actually promulgated by them. And so what I thought I would do is I would start out by, I guess one of the best places that I remember that I was on a radio interview the other night, 2 nights ago, and they started asking questions that reminded me of an incident when back in 1977, when I was at Jesuit National Headquarters in Washington, I was having dinner with Rosemary Chalk, who was an executive secretary at the National Academy of Sciences, and she was remarking that how amazing it was, all these cases that I'd gotten to be in by that time, with the Pentagon Papers case and the case that established the right of journalists to protect their confidential news sources, and the Karen Silkwood case about the woman that was killed up at that nuclear facility, and and the Watergate burglary case. And she said, you must have be kind of like a born lawyer, that you must have always just known you were going to be a lawyer. And I pointed out to her that no, that wasn't true, that actually I was going to be an astronaut. That every red-blooded American boy, to the exclusion of the women at that point in time, when I was in high school, all wanted to grow up to be astronauts. And I particularly did, and I was going to go to the United States Air Force Academy, and had applied to the Air Force Academy, and was actually the #1 candidate for the Air Force Academy from the state of New York for the senatorial appointment. And I went down and talked with Jacob Javits, who was one of our United States senators, he and Kenneth Keating, and he had the responsibility for interviewing the candidates for the Air Force Academy. And I got partway into the interview, and he felt constrained to tell me that he'd already given the appointment to someone else, even though he isn't supposed to. But he felt that it was required by candor to tell me that he'd already given the appointment to the actual son of one of his major campaign contributors. But he offered me the appointment to the U.S. Naval Academy, saying, look, you could still be an astronaut, you could still be a pilot, and get to be an astronaut through the Naval Academy. I told him I wasn't into boats. I'm into airplanes. And he was saying, no, you can still get it. But he said, look, you can go down to your congressional district and get your appointment from your congressman. And so he said, I'll call Carlton King, who is your congressperson, and tell him, that you should get this nomination. It's clear he'll want to do that anyhow. So I went back to the congressman, and it turned out that the congressman had given the appointment to the son of the mayor of Glens Falls, which is one of the big cities in his congressional district. I was deeply offended, still at that point, being naive. And so I said, well, hell, if this is the way it's going to be, I'll be a lawyer. And I said, and then what I can do is I can take some time and work on the system to get the system retuned, because it seems to be a little bit out of tune here from this type of corruption. And so then I'll help get the system retuned, and then I'll get back to being an astronaut. But you'll see that I'm not an astronaut. I'm still a lawyer, because it turns out, I found out that the system wasn't just a little out of tune. It turns out that it was playing an entirely different song than we had been taught. So that's how I got into this. What I did is, when I discovered that I wasn't going to get the Air Force Academy appointment, it turns out that I had not even applied to any other college, because I was the #1 candidate from New York State. And so there wasn't any way I wasn't going to go, but I didn't. And so my aunt had applied to Northeastern University, which I didn't even know where it was, for me. So I get the scholarship to Northeastern University to start. And it turns out that at that point in time, 1963, that John Kennedy is president at the time. Pope John the 23rd was Pope. Really terrific, nice guy. There was lots of good things happening. Everybody was very optimistic, but every man in the country, when you turn 18, was required by law to go and sign up to join the military, because every male had a 2-year military obligation. It should have given me some kind of hint that there was a bit of a militarism going on in our country. But nobody even thought about that kind of thing at that time. So when I went to Northeastern University, I signed up for the U.S. Special Forces. And I said, look, if you're going to really do it, you might as well do it and learn how to jump out of airplanes and blow things up and do that kind of thing. But turns out that 2 years into the program, I was out at Fort Devens in Massachusetts, where we were based, the 10th Special Forces out of there, and was actually instructed in one of the courses that we were doing, what's called halo diving, the high altitude, low opening chutes. You jump out at 40,000 feet and time yourself falling into the night, with black chute and black face and all that. And this little short dude that was teaching us how to do this told us that when we landed, what we had to do was, if anybody saw you land, because you're parachuting in behind enemy lines, that if anybody sees you, even if it's a woman or a child, you have to kill them immediately and bury them with your chute. And I was sitting there because it reminded me of what had happened. As I was getting ready to leave to go to college, my Uncle Jim, that I grew up with, pulled me aside and pulled me out into our front yard up in north of Lake George, New York. And he stood there next to me, and he said, "I want you to look out there, Dan." I looked out, and from our home you can only see 100 miles of woods, between us and Canada. And he said, "You see out there?" He said, "There's going to come a point in time when Russians are going to be parachuting into our town. And I want you to assure me that you will fight when they do that." Well, I thought he was totally full of shit, but I didn't want to say it. It was going to be the last day I was going to see him anyhow. So I said, "Well, look, Jim, I don't really think there's going to be Russians parachuting in." But he said, "But just tell me that you'll fight." I said, "Look, I'll tell you what." I said, "I'll agree. If anybody parachutes into our hometown and tries to take it over, I'll definitely fight. I will protect our country against all enemies, foreign and domestic." And so anyway, but I didn't know who I was talking about who our domestic enemies are at that time. And so it reminded me that when all of a sudden I'm told by this guy that we have to parachute in to Vietnam, to North Vietnam, where people have lived for 10,000 years, for like 300 generations have lived there, parachute into their backyard and kill the women and children and bury them with my parachute. I said, "Fuck this," literally. And I got up and I walked out. And so I walked out to the door, and Captain Campbell, who was our commander, said, "Sheehan, where the hell do you think you're going?" So I turned around and I said, "Look, somebody around here is totally nuts," I said, "and it's not me." So I left and I quit and walked out and went to Harvard College. Transferred out of Northeastern University and got a full scholarship to go to Harvard College. And the bottom line is, they decided what they were going to do is they were going to draft me. So I got drafted in 1965, 2 years into college. And the draft board said to me that, I said, "Look, I'm enrolled at Northeastern University. I'm now enrolled at Harvard College." They're saying, "We drafted you in between times, after you left Northeastern University and before you enrolled in Harvard College." Total absolute lie. I mean, I'd been enrolled in Harvard College for 2 weeks before I ever told anybody at Northeastern that I was even withdrawing. So it was just, here I was confronted by a complete, absolute, bald-faced lie on the part of the draft board, because they were just PO'd over the fact that I'd resigned from the Special Forces training. And I wasn't going to do it, even though I was 2 years into it. And so I was confronted by this absolute travesty of justice, of the draft board lying, committing total perjury just to try to retaliate against me for leaving. And so I basically told them I wasn't going, and that if they wanted to fight about it, I would call as witnesses all of the people who heard us instructed to kill women and children. And I knew who was in the unit with me and who the captain was and everything. And so they got totally confused, and they went to my Uncle Jim, the guy who knew the Russians were going to be coming into our hometown, and who was on the Republican County Committee, and said to him, "Jim, what's the story here? This is Danny. He was the president of the student council, the captain of all of our football teams and everything, and was the Boys State, was the nominee for governor of Boys State in New York. What the hell's wrong with him here? What's happened to him?" And Uncle Jim just said, "Look, I don't know, but I can tell you this. If he says he won't go, he won't go." And so they left me, they reclassified me 1A. So that means that they could redraft me at any moment they chose. And then I continued at Harvard College. And when I was at Harvard College, the lessons continued. Because when I got there, one of the first things that they assigned for me in the government course was to read Arthur Moss's book, called the Development of Water Resource Systems. A completely boring, dry book for a water resources book. But it turns out he was the chairman of the government department at Harvard College. And what the book told us about, it told us about how there was a group of citizens in Arizona, in the Southwest, that wanted to develop a water system for their area, public water for their people. And they kept on applying to the legislature and the federal government, everything, to try to get subsidies to do this, and nobody would do it. And so he said, what you really do, here's how you do it. Now that you're here in the club, now that you're at Harvard and you're going to be running the world, he said, look, here's how you do it. What you really have to do is, instead of going through the normal channels and applying for it and showing the merits of the program and everything, what you really do is you go and you find the people who are going to make the most money on this. The big agricultural corporations, the people that are going to sell the concrete for all the culverts and all of that, and you organize them and you get them to give major campaign contributions to all of the key people on the committees in Congress that have to approve this thing. And then you go and you talk to your senator and your Congress people and get these people to give contributions to those guys so that they'll stand up for you. And he lays it all out in detail about how the system really works, and showing this that we really need to know how to do this, right? I was totally offended by that. Still, as I said, being a bit naive and being offended that they were suggesting that that's how we should really do things. And so I wrote my junior essay, honors essay, condemning him, the chairman of the government department. And one of the three graders that I had gave me an F just for doing it, for saying things like that. And the other guy of the three gave me a straight A, saying that he thought it was a very sound analysis and a legitimate point of view. And so they brought in a third person to break the tie. And fortunately, he gave me an A. And so I went on into the honors program at Harvard College. But again, I was struck by not only the kind of crass way in which Arthur Moss, as the chairman of the government department at Harvard, was recommending that we proceed to get things done in the country, but the fact that the people that were on the faculty would be so picayune is that they would, try to give me an F simply for challenging the guy, the head of the department. So that was. And then I decided what I was going to do is I was going to take special courses at Harvard College to study about the Vietnam War, because I was so offended at them trying to draft me and understanding what they were really doing. And then I came to discover what a complete bunch of lies were going on about Vietnam, how the United States had just gone in and taken the place of France, that France had actually taken over Vietnam back in like 1898 by sending a gunboat into the harbor at Saigon. And when the naval people went ashore from the French Navy, they ended up, the sailors ended up getting into a fist fight with people at the local market, and then withdrew and fired on the city and took it. And when they contacted back home in France, they said, what are we supposed to do? They said, keep it. Just keep it, because, there's a lot of colonies being built now by England and other people. U.S. is taking over Cuba and, in the Philippine Islands and Hawaii and everything. So we'll just keep this. And so they were there for that whole period of time until the Japanese invaded at the beginning of World War II. And the Japanese drove the French out. And then when it came to the end of World War II, the French went back in. And it turns out that Ho Chi Minh and a whole group of people in Vietnam organized themselves, who had been fighting against the Japanese, and they started fighting against the French. And they surrounded them at a place called Dien Bien Phu, General Giap, actually, and surrounded them on the mountaintops and started massacring them, the French. And so the French gave up, and they struck an agreement that the French would withdraw. and they would be allowed to withdraw below a certain parallel in Vietnam. But under no circumstances could anyone consider that line to be anything but a temporary line behind which the French could withdraw and then leave the Vietnam Peninsula. But what happened is they ended up having a general agreement at the Geneva Agreements of 1954, explicitly making that official, and the United States intervened and said that they refused to endorse that. And so they then went and they recruited a guy by the name of Ngo Dinh Diem, who was a graduate student at Columbia University at the time from Vietnam, and brought him back to Vietnam and put him in charge of being the head of South Vietnam. They just sort of came up with this idea, let's have a South Vietnam, and we'll give it immediate recognition, and we'll send in military advisors and give you all the military equipment and training and everything to hold this territory. And the United States just started sending in troops to basically hold the southern half of Vietnam away from the people who had lived in Vietnam, as I said, for 10,000 years. So we discovered that was what had happened. And here we are, here I am at Harvard College learning about all this stuff and realizing that our whole government was giving us this big ration, telling us that, that there was a democratic republic in South Vietnam and that all these horrible, nasty, atheistic communists were going to be coming down from the north and invading them. And it had a strange echo of sounding like Korea. So the same thing was being done. The United States was doing the same thing on the Vietnam Peninsula that they had done on the Korean Peninsula. So they were just taking the lower half of it by military force and holding it. And so I realized that not only were the things that I was being trained to do in the Special Forces totally violative of any kind of standards of decency, but that in fact the entire enterprise was the same. That it was completely contrary to not only all the values that we had and had been taught, but that in fact was totally contrary to what was being said by all of the news media. That were just cheering away and telling great stories about our wonderful troops and how valiant they were and all of that, and inflating the body counts and telling all the horrible things that the Viet Cong were doing, not dissimilar to what you're being exposed to today. With regard to Iran and Afghanistan and Iraq and other places. And so when I got done at Harvard College, I was nominated for the Rhodes Scholarship from Harvard College because I played football and baseball and stuff. And so I was getting set to go to Oxford to just study for 2 years and get kicked around playing rugby. And it turns out they drafted me again. So they came back and drafted me a second time, at which point I confronted them and started submitting data to them, but they said I couldn't leave the country for more than 2 weeks without having an official letter from my draft board allowing me to be out of the country because I was 1A. And so I sent a letter to my draft board saying, hey, how about you give me a letter authorizing me to be gone for 2 years to do my master's work there. And they sent back, again, official reconfirmation of my being drafted. And so I just went up to Harvard Law School. I took the full scholarship to Harvard Law School, went up to Harvard Law School, and became the chief research assistant for Professor Jerome Cohen, who was the head of the International Law Department at Harvard, who was writing a book about the illegality of the war in Vietnam. And so as his research assistant, I was just sending one chapter after another to my draft board. Saying, look, here's the details. If you want to handle this in court, here's the evidence, and here are the expert witnesses, and I'd be happy to do this if you want to do this. So they ended up sending me a notice that I was 1Y, which meant that because I'd had water on one knee while I was playing varsity football in college, after having passed the Air Force astronaut physical and the Special Forces physical, that I was 1Y. Because I'd had water on one knee at one time, and therefore they were going to hold in abeyance the draft order. So I went up to Harvard College, and the lessons continued. When we went in, I started taking constitutional law as one of the courses. Al Sachs, who was my first professor, who used to be a clerk at the United States Supreme Court, was telling us about the different cases. And one of the cases was a case called Hirabayashi. Hirabayashi versus the United States. And this had to do with a young third-generation American, Japanese American, who after the bombing at Pearl Harbor in December of 1941, it turns out that President Roosevelt had issued a presidential executive order, Executive Order 9066, in which he just declared by fiat that the entire United States was therefore going to be divided into 10 separate military districts, and that the military commander in each district, the U.S. Army military commander, was authorized by the president to issue edicts that had to be obeyed by all the citizens. And one of the edicts that was issued by General DeWitt in the 1st Military District here on the West Coast was an edict prohibiting any people of Japanese ancestry from being out in public after 7 o'clock in the evening. And this young fellow by the name of Korematsu, or Hirabayashi rather, Hirabayashi up in Seattle, Washington, was out doing barbecues and stuff, and the MPs came by and arrested him and prosecuted him for violating this rule that was issued by a general based on an order from the president without any legislation whatsoever authorizing it. And so he protested and was convicted and sent to a military prison, and he appealed it. And they appealed it, and it went all the way up to the United States Supreme Court. And the United States Supreme Court just sat there looking at it, saying, gee, this guy's asserting here that the President of the United States, under our Constitution, doesn't have the authority to simply issue, executive orders and then have a military commander tell you what you can do or can't do. It seemed like a basic constitutional premise. And it went all the way to the United States Supreme Court. And Al Sachs starts telling us that what happened is when the justices of the Supreme Court got this case, they looked at it and they said, gee, this argument that he's making here, that there's no congressional authorization for an act like that on the part of the president, who's supposed to be just executing the laws, not making them up. And it turns out that the Chief Justice of the Supreme Court, Al Sachs tells us in the course, who was in fact a law clerk at the United States Supreme Court at the time, said that the Chief Justice called one of his law clerks in and handed him an envelope and said, here, I'd like you to bring one of these envelopes to the Speaker of the House and another one to the Majority Leader in the United States Senate. And it turns out that they were a statute that, if passed, would purport to authorize the President of the United States to issue an executive order like 9066 and authorize the general to implement it. And they went ahead and they brought it to them. They immediately held hearings, like a 1-hour hearing, and they all rushed out and they all approved it. And the statute got passed. And then they agreed to listen to the case. So they allowed the Hirabayashi attorneys to come before the Supreme Court, and they said, oh, this is a very interesting point you've raised here about whether or not the President of the United States has the inherent authority to issue an edict like this and have the military take over an entire area of the country. But fortunately, you're arguing that they couldn't do it without congressional authorization, and it turns out there is a congressional statute here now. You might want to make the argument that it was an ex post facto law, but we don't see that anywhere in your briefs because they had just passed it, right? After he'd already briefed it at the court. And so Al Sachs was telling us, what he was telling us in that first constitutional law course at Harvard Law School is that you need to understand that there are political limits on what it is that you're really going to be able to do as an attorney just going to the courts to try to get them to enforce the laws. So there are political limitations. And that was one of them that he pointed out, that if in fact you're flying in the face of the kind of general consensus of all of the leadership of the government, you aren't going to be able to win, no matter what the law says. And so that was a painful piece of information. And then Lawrence Tribe, came on to become the constitutional law professor at Harvard Law School. And in his courses, he was attempting to teach everybody at Harvard Law School that the law of the United States, the constitutional law of the United States, is kind of one smooth fabric, and that there are a whole set of precedents that get ruled on by the United States Supreme Court. And you read them and understand what the principles are, and if you can discern a principle in there that might be extended a bit, you can make an argument that the next court ought to extend it a bit. The people who were opposed to you, usually the state, in a constitutional case, would argue that they shouldn't extend it any further than the last case that was decided. And so he was suggesting that this is an extraordinarily intellectual and kind of philosophical undertaking as a constitutional litigator of dealing with these nuances in the various opinions and sort of continuing this ever-evolving flow of constitutional law in their principles. But at the same time, we're being told in reality that there is this fundamental conflict going on inside the courts between these kind of reactionaries on one side and these kind of progressives on the other side. And though they didn't want to say so directly, it pretty much coincided with the Republican appointees who were doing the reactionary activity and the Democrats that were the kind of progressives. And so I was trying to figure out, exactly what the principles were that the Republicans stood for that was causing them to be so reactionary, and what the principles were that purportedly was causing the Democrats to be more or less progressive in their judicial interpretations of what they pretended to be neutral principles. And that's where I first came across this article, this natural law in the American Constitution that I asked you to read. If you haven't read it yet, you should. Okay, but this is a classic announcement of the natural law theory and what its relationship is to the United States Constitution. And you read through the entire thing, and you sort of come to discover that you can't quite figure out what they're talking about. They keep making reference to natural law and the fact that there are these kind of innate principles that you keep making reference to as the Constitution. But you can't find out where the there is. Where's the beef on this thing? If you really want to be arguing from something other than just looking at what the courts have already said so far and asked to go just one little bit farther, that's basically being, in a sense, a mathematician. You basically are trying to discern the kind of algorithm that kind of rises up, deductively out of the, or inductively, up out of the decisions, and that's as far as you can go. You can go the next little baby step, but that's not much of a principle. It's certainly not consistent with the kind of high-flown language that you hear in law review articles like this about natural law. That is talking all about these primary principles that are obvious to everyone by dint of our human nature. And so I couldn't quite figure out what it is they were talking about at the time. But then I discovered that there were some hints, such as are found in the second reading that I asked you to read, which is this section from the Encyclopedia of Philosophy, that you have the whole section on e-commons, and it talks about natural law. And what it does throughout the 3 pages of this is talking about the correlation between the natural functions that occur in the physical universe, in nature, and some intrinsic principles that can be discerned on the part of the human person. And in that one particular section that I directed your attention to, that is on the page 3 of this, this is this section that talks about the nature and reason. It's on page 452 or 432. Let me see which one this is. 452. It's in the first column on the left, just to try to get you as precise as possible so you know exactly what we're talking about. There's this section in here that says, talking about natural law, it says, it was characteristic of much of the post-Reformation thought to abandon a teleological and metaphysical thinking in juristic writings. And so they begin talking about this, and they say that at this stage, the logical and epistemological aspects of theory come together. Natural law was what reason can discover. Now, you think, okay, therefore you're getting some idea now that somehow by simple reason that you can figure out what the natural law is. But then in the very next sentence it says, but serious difficulties still remained, as they did not generate a philosophy for the age over how to interpret reason, which was sometimes equated with, and here I want you to get this, reason, pursuant to the natural law theory discussions, sometimes refers to intuition, sometimes with the cool observation of physical nature, and sometimes with decisions of the law of non-contradiction, which means simply that the legal arguments have to be internally, self-referentially consistent. So you can apply kind of logic in those logic classes that you're having as philosophy majors. So what they do is they suggest that while they cover the field in saying that, well, we should be able to discern by our reason what the natural law principles are, the fact is they give you three entirely different interpretations of what reason means. And very importantly for our purposes, the first one that they mention is in fact intuition. And so I had this stuff put in front of me at Harvard Law School, but they didn't really go into any great detail about it. What we did is we spent virtually all of our time just reading specific cases and discerning what the kind of general rationale was for a particular set of decisions, and then trying to figure out if there was some sort of principle that you could discern lying in there somewhere and could extend it one baby step. And yet here's all of this highfalutin talk about intuitional perception through a certain form of reason in the human mind to be able to discern these principles. And that's when, in December of 1968, right, still in our first semester at Harvard Law School, that this event occurred that I told you about, that Professor Crane Brinton, the longtime chair of the Department of Intellectual History at Harvard University, was having his final lecture. After having been there, he graduated from Harvard and then went over to Oxford and taught there, and then came back and was for like 35 years the head of the Department of Intellectual History, was asked in his final lecture to identify, if he would, what he thought the single most important intellectual insight was in the history of his study of intellectual history. And he said in his lecture, I was there for it, went down from the law school and was present there for the lecture, in which he said is that he was convinced that the greatest minds of the human family had all come to realize that our human family is actually in the midst of a process of major biological, physical evolution, and that we're evolving a new faculty in addition to our seeing and hearing and touching and tasting and feeling, that there's a new faculty, a biological faculty that is evolving in the human family, by means of which we can directly, experientially encounter the unitive phenomenon that bonds every single ultimately irreducible integer of matter in the entire physical cosmos into one unified harmonious whole. And that by dint of that direct experience, like seeing or hearing, that each individual human being is capable of determining what type of human conduct, either individually or collectively, is either harmonious with or disharmonious to the natural order of the universe. Now, this is probably the most important single thing that you're ever going to be able to learn in the entire courses that you take in college. And certainly the most important thing that you're going to learn in this course, that this is a postulate set forth by the 35-year chairman of the Department of Intellectual History at Harvard University, setting forth this conclusion that he came to in his final lecture. And I'm suggesting to you in this course that this is the phenomenon that you have to keep your eye on when you're talking about natural law. Because all of this other discussion about reason and internal self-referential consistency and logic and everything else, or even looking back at the traditions of what traditional things have everybody agreed together are right or wrong, or what the particulars are of a particular culture that you happen to find yourself in, that those issues are how you determine what is right or wrong in natural law. But this you need to keep your eye on, okay? Because this is what they're asserting, and I'm suggesting to you in this course that this is what's really going on. That individuals, just like some individuals can see better than others, some individuals can hear better than others, some individuals are more intellectually astute than others, can figure out discerning patterns in arithmetic and geometric patterns they can discern inside certain data, and can project it out kind of through an algorithm into the future and make general predictions more accurately than others. But the fact is that if there is this other faculty that is evolving, it evolves at different levels and at different rates in different people. And what we've discovered in studying natural law, that the intuitionists are referencing this experience. That it's something that one just by intuition can seize upon and understand immediately. Now, as to how effectively they can articulate it, and whether they can lay out a set of objective principles that need to be followed, is a matter of discussion inside the issue of natural law. But as I say, when I was at Harvard, this was the only hint of it that I was exposed to, except for the time when you read about natural law, they make these vague references to intuition. But you can't quite figure out what they're talking about, and they don't spend any time directing their attention to it to help you unpack it or understand it. So I continued on at Harvard Law School, and we went on into 1968. And in the spring of 1968, the war was raging. A great opposition to the war had arisen. The Lyndon Johnson, who had taken over as president for John Kennedy when Kennedy was killed in November of 1963, he had come on and he finished the last 14 months of that term in office, and then he went on and had a second term, a full term from 64 to 68, and then he was standing for the presidency again in 68 for a new term. What happened is there were a whole bunch of us all across the country that were students just like you that were saying this is an outrage, that he's carrying on this horrendous war, it's got to stop. And so what we were trying to do is we were trying to talk Robert Kennedy into running for the Democratic presidential nomination against Lyndon Johnson. We had broken out of this mirage that all the good guys are inside the Democratic Party and all the bad guys are in the Republican Party. We realized that there were a bunch of bad guys inside the Democratic Party, and Lyndon Johnson was one of them. And so we wanted to get rid of him. And so a couple of my professors, Abe Shea, who I studied international law with, and Adam Yarmolinsky, whom I studied actually urban public policy with, Abe Shea was going to be Bobby Kennedy's Secretary of State if he won the election. And Adam Yarmolinsky was going to be his Secretary of Defense. And since they were two of my professors, I was going to be working with them. And so we were a bunch of us working together to get Bobby to come out and agree to run against Lyndon Johnson for the Democratic Party nomination in the spring of 1968. And he wouldn't do it. Bobby wouldn't do it. He said, it's destructive of the Democratic Party. We have to remain loyal to whoever the head of the party is, and blah, blah, blah. And so a bunch of us got together, and Joe Grandmaison and Gary Hart, young students at the time, went to see Eugene McCarthy, the senator in Minnesota, and got him to agree to run and to mobilize all of the opposition against the war in Vietnam against Johnson. And Eugene McCarthy ran against Lyndon Johnson in the New Hampshire primary in March of 1968. And in March of 1968, I think it was March 15th or so of 1968, actually I think it's March 13th, they voted on this, and Lyndon Johnson got 49% of the vote, but Eugene McCarthy got 42% of the vote. And so it freaked out Lyndon Johnson, and 3 days later, Bobby Kennedy agreed he was going to come in to the presidential race, and he announced, and 4 days later, Lyndon Johnson withdrew from the presidency. And so Bobby Kennedy was then going into all the rest of the primary contest and was basically blowing everybody out and was getting ready to win the presidential nomination. And then in the spring, in April of '68, Martin Luther King gets assassinated in April. And then on the night of the the night of the California Democratic presidential primary on June 5th of 1968, Bobby Kennedy gets assassinated. And so it kind of took the wind out of the sails of everyone that was opposing the war. And so they had to try to turn back and start supporting Eugene McCarthy, who didn't have a whole lot of the votes because Bobby had taken them all. And so Eugene and Hubert Humphrey, who was the vice president under Lyndon Johnson, ended up being given the nomination. It all took place at the Democratic Convention that you may have heard something about. Back in 1968, in August of 1968, there was a huge confrontation that went on at the convention, and the Chicago police rioted and attacked all the students that were demonstrating at the convention. And so there was a huge disruption that occurred in the country back in 1968. It's kind of an archetypal year in the history of the baby boom generation. And what happened is in the final election in November between Richard Nixon and Hubert Humphrey, Richard Nixon ended up winning 43% of the vote, and Hubert Humphrey ended up winning 42.7% of the vote. So there I was in the internal use of Democratic and Republican Party politics as the defining differentiation between the good guys and the bad guys was failing miserably. And here we had, of all people, Richard Nixon being the guy who was President of the United States, and we all had to pay homage to him as the president. So we went forward at Harvard Law School, a bunch of us, and we organized the Joint Student Faculty Committee at Harvard, and we organized the Harvard Civil Rights Law Review. And I was one of the co-founders of that with Mark Green. We founded the Harvard Civil Rights Law Review and decided that what we were going to do is we were going to utilize the Constitution and the Bill of Rights to protect the people in our generation who were mobilizing to stop the war in Vietnam. And so we began to do all kinds of things from the Harvard Civil Rights Law Review to represent particular people, the Vietnam veterans against the war that had developed, that I ended up representing the first U.S. Army band, the first U.S. Army regimental band down in New York City. A young fellow who had was at the Juilliard School of Music, got a full scholarship, got drafted, and brought into the U.S. Regimental Band, became the drum major, and he organized all of them to take out a full-page ad in the New York Times listing their name, rank, and serial number opposing the war in Vietnam. And the commander, the general of the 1st U.S. Army, went berserk and threatened them all that if they did anything like that again, that they were going to be punished, that they'd be deprived of the right to live off the military base where the band lived. They'd be deprived of their right to get free music lessons. They would be assigned KP and all of that. And so they contacted us, and we stood by and prepared a federal civil rights complaint to protect them against any further retaliation. And what happened is they, feeling their oats, the 1st U.S. Army Regimental Band decided they were going to march in the 4th of July parade, and they were marching in the 4th of July parade out on Long Island, and all of their fiancés and girlfriends and wives were marching along next to them on the sidewalks carrying signs like "Nixon War," and does the fact that we've killed 10,000 people make us great? And the veterans of foreign war that were marching in the 4th of July parade went crazy and attacked them and broke their signs and knocked them down and kicked them. And of course, it was all on national television. It goes out on, because everybody has to have their footage of their local 4th of July parade. And so all of the local ABC, CBS, and NBC television stations had footage of them doing this. And so it went out across the country. And so they contacted us immediately and said, oh, gee, we're going to get in big trouble. So we said, look, here's what you do. They got called back in the next Monday morning, and they were ordered back to live on the base. They were ordered they weren't going to get any music lessons. Everything that the judge or that the general had laid out earlier, including the fact that they were assigned to KP. So what they did is they were assigned to clean up the general's office, General Higgins. And so what they did is one of the assignments they had was the burn bag, that all the classified documents and stuff would be thrown into a burn bag. And so what they did is they, per some intelligent instructions from people from the law review, what they did is they opened up the burn bag, and what they have is they used to have ribbons, these little inked ribbons that were on the typewriters, the manual typewriters. And when they would get done typing one letter that was a classified letter, they'd take the ribbon and throw it in the burn bag. And so what the kids did is they pulled all the tapes out, all these little ribbons, and they held them up to the light and read what was typed on them. And there was the letter from General Higgins to the commander at the United States Pentagon, ordering the entire 1st U.S. Army Regimental Band to frontline combat units in Vietnam. And so we ended up going in front of a judge in the Eastern District of New York, the federal district court. We got local counsel, was Fred Cohen, and the people from the law commune in New York, and went before the judge and revealed to them what we had there in a really interesting set of hearings. But the bottom line is the federal judge in that case, a Democrat who actually taught constitutional law at NYU Law School, actually entered an order not only commanding the general to bring all of them back on the next first-class commercial airliner and bring them back to New York, but also had to build and assemble a major bandstand on the parade grounds of the 1st U.S. Army Band and get up in front of the entire assembled 1st U.S. Army and publicly apologize to all of them, including the wives and girlfriends, about what he had done. And so we saw that you could use the First Amendment of the Constitution as a weapon to fight back against these kind of oppressive people. And we did it in a number of cases. Another one of the cases was the Black Panther newspapers. It turns out that the Black Panthers had taken a very aggressive stand against the war because such a high percentage of young black men were being drafted and the white kids were being given 2S deferments, all except for me and a couple others. And so that they were taking aggressive positions against the war. So all the Boston police hated them. So whenever a notice went out that a robbery had been committed by a young black male, between the ages of 20 and 30, between 5'6" and 6 feet tall, what the police would do is the Boston police would go out and they would arrest every single young black man that was selling copies of the Black Panther newspaper on the street corners. And they would go out and arrest them all on the suspicion that they were the perpetrator of this robbery. And then they would put them in lineups all day long into the evening, hoping that someone would mistakenly identify them as being the perpetrator of some other crime. And then they'd come the next morning, they were going to have to bring them in front of a federal magistrate to show probable cause as to why they'd arrested this person, so they would then let them go. But that all the Black Panther newspapers that they had confiscated would have disappeared by that time. And so we thought this was rather a raw demonstration of a violation of the freedom of the press. And so we brought on a major federal action using a young lawyer in Boston, this was, and got a federal court order, stopping them from doing that, a federal injunction prohibiting them from doing that. And because of that, we ended up being contacted soon thereafter when in April of 1968, when Dr. King was assassinated and the riots were going on around the country. Turns out the Black Panthers in New Bedford, Massachusetts. It turns out that the mayor in New Bedford, Massachusetts, because riots were going on all across the country in a lot of the major cities, including New Bedford, the mayor of New Bedford issued a decree ordering the police to shoot on sight anybody that they saw engaging in looting. And so what the Black Panthers did is they barricaded off the entire roads coming into the ghetto and armed themselves and got up and manned the barricades and at gunpoint kept all of the police out of the ghetto so they could not come in. And so there was a major to-do went down, and all the major news media started gathering around, and all of the state police came in with their snipers and gun turrets and armored personnel carriers and stuff and surrounded them. And there was this major standoff went on, and a young reporter by the name of John Pappas from NBC, the local NBC affiliate, kept going to the barricades trying to get the Black Panthers that were there armed behind the barricades to give them a statement as to why they were doing this. And every time he would get near them and start holding out the microphone to them and they'd see them, they would all go, "Fuck you, fuck you, put that on the 6 o'clock news." And so they were going, oh no, they couldn't get any footage of anything to put on their news. And so that they were getting very frustrated. Finally, after 2 days of this, the Black Panthers got wind of the fact. They heard that the police, the New Bedford police and the Massachusetts State Police and National Guard people that had been called in were going to go in with an airlift and raid the Panther headquarters. So they decided they were going to reach out to this young guy, John Pappas, who seemed to be very persistent and constantly coming and trying to get them to give a statement. And so they invited him behind the barricades and said, "Look, we want to give a statement as to why we're doing this thing. And if you will put that on the 6 o'clock news at your local NBC affiliate, we will agree to then invite you in later tonight and you can interview anybody in the headquarters that you want. And we think there's going to be a raid by the police on our headquarters in the morning. And you can interview anybody all night that you want, and anybody that wants to talk to you can do it. And when the raid comes, you video that and put it on your news. And you can use any of the interviews as a backup to your story. Now, if they don't do the raid, then you can't use any of that material. You have to keep it as just deep background, understanding of what's going on here. And so he ends up making that agreement. All their lawyers at the station, the local NBC affiliate, all agreed to do this. They got the statement from them. They put it on the 6 o'clock news. They got invited back in, John Pappas and his team, and they went into the Panther headquarters, and they were there all night interviewing people, cleaning their rifles and their guns and stacking ammunition around the windows, getting ready for this big police raid in the morning. And in the morning, no raid took place. So they gathered together all their footage and everything, and they left. And they went back to the NBC affiliate. The attack came the following morning. Okay, and the police came storming in and dropped satchel charges down their chimneys and blew them up and burnt the place down and arrested a bunch of them. And the enterprising young district attorney, state district attorney in the city, impaneled a special grand jury to start looking into the potential connections between the cause of the riots and the Black Panther Party. And the first person that they subpoenaed was John Pappas from NBC Television News. And they ordered him to come in and bring in all of the outtakes of everything that he had, and also to personally testify about everything that he saw and heard, identifying people that were in the place and what they said. And so he didn't want to go because he thought that it was violative of his agreement with them, the confidentiality. And so he went to his bosses at NBC. They went to their lawyers, and the local NBC lawyers said, well, we don't think he has any right to resist because the DA has gotten a grand jury to issue a subpoena for John Pappas. And so, gee, there's nothing we can do. And so then they called their national counsel at the Cahill-Gordon firm in New York and asked them, and Cahill said they didn't think there was any right to resist the subpoena. And so the guy called us because actually the Panthers out in New Bedford called the Panthers in Boston because they had just won this major case in Boston against the police department for stealing all of their newspapers. And so they said, would you get the same people who did that to help us here? And so they contacted us at the Law Review. And so we moved in and we drafted up the very first assertion in the country of the right of news journalists to protect the confidentiality of their confidential news sources and the information. And we went up to the Massachusetts State Supreme Court with that demand, all the way to the United States Supreme Court, and the United States Supreme Court agreed to hear the case. So here we were, second-year law students here at Harvard Law School, and we had a case up in front of the United States Supreme Court, at which point the Cahill-Gordon firm in New York went back to them and said, okay, we'll do your case in front of the Supreme Court. Of course, John Pappas, having an IQ at least in double figures, said, no way. Why should we have you argue this case in front of the United States Supreme Court when you didn't even believe that such a right existed anyhow? We want these kids from Harvard Law School to do it, which turned out to be me, actually, these kids who had done the briefs. So I ended up getting contacted by Cahill-Gordon, Sonnet, Rindell, and Ohl, the #1 litigation law firm in the world, representing NBC News, and hired me right up out of Harvard Law School. So I ended up going to Wall Street out of there in representing the NBC and got to write all of the amicus briefs in front of the Supreme Court for ABC and CBS and the New York Times and the Washington Post, etc., and be preparing to argue that case of the right of journalists to protect their confidential news sources. And so I was in the meetings with all of the presidents of NBC and everything, working out the policy positions here, when in fact the New York Times got the Pentagon Papers. And so I actually received the call from the executive vice president and general counsel, Jim Goodell, from the New York Times. And he came in early in the morning to our office, and we sat down, and I was there in the meetings where we decided to publish all 47 volumes of the top secret classified Pentagon Papers. And we had a set of them that were copied, that were up at the Plaza Hotel in these 2 big suites with the 47 volumes lying all around and on the toilet seats in the bathrooms and everywhere. And we were going through them to determine what information we were going to publish in the New York Times. And so we began publishing on the 13th of June. We published on the 13th and 14th of June. And on the 15th of June, I received a telephone call at my office at the Cahill firm from Whitney North Seymour, who was the United States Attorney for the Southern District of New York in Manhattan. And he said, hello, Mr. Sheehan? I said, yes. He said, this is Whitney North Seymour. And I said, Whitney North Seymour, Whitney North Seymour. Am I supposed to know who you are? He said, I'm the United States Attorney in the Southern District of New York. I said, oh, right. I said, oh, that Whitney North Seymour. And so he said that he wanted us to stop publishing the papers. And I said, oh, really? You know, he said, yes, I want you to stop publishing these papers. And I said, well, I thought you probably would. And he said, well, you know, we're going to go to the federal court here and get an order telling you to stop. And I said, you mean a prior restraint? You know, you're going to prior restraint on the New York Times, is that right? Oh, he says, I don't want to quibble over what we're going to call it. And I said, no, I was just calling it what it's been called since the very founding of the country, you know, a prior restraint on the press. He said, well, anyway, we're going to be there tomorrow at 1 o'clock, and you can come or not. And I said, oh, we're pretty busy over here. I don't know whether we're going to be able to make it, but, you know, I appreciate the courtesy call. And so we went up and had the conversation. We all went over there. And so I was in all of the closed-door hearings, you know, with the judge figuring out what they're going to do about the Pentagon Papers. And we went from the federal court there, the district court, to the 3-judge panel, to the full panel of all 13 of the judges on the Second Circuit Court of Appeals, all the way to the United States Supreme Court in 13 days. And we won the case. And they declared the First Amendment right of the New York Times to publish top secret, classified Pentagon internal documents on the front page of the New York Times. And so a lot of people will ask us, you know, well, how did you do that? How did you get that done? And you'll have to take the next course to get into those kind of details, because I don't want to have to get into all kinds of the technical minutiae. But here we were again now, having confirmed to me that we could actually expose some of the deepest and the darkest lies of the executive branch through the use of the Constitution, through the use of the First Amendment, right to freedom of the press. Just like we'd won the case for the First U.S. Army Band on the grounds of First Amendment freedom of expression. And freedom of the press, since they had the full-page ad in the New York Times. So I was getting these mixed messages about there being this kind of dark history that was really going on, because in the Pentagon Papers case, it revealed, for example, the fact that the whole Bay of Tonkin resolution that was passed by Congress authorizing the president to use force in Vietnam, that the whole thing was a complete charade. You know, the whole assertion that our U.S. Henry Knox and the other radar picket destroyers were physically assaulted by Vietnamese PT boats. You know, I mean, the whole thing was just a complete crock, and they knew it. But they just set it forth, and on the basis of that, they stampeded the Congress to all signing this thing of you can go and invade Vietnam. And so we proved that. We proved that they were engaged in heroin smuggling that was being used to secretly finance a massive political assassination program, the Phoenix program, that killed, you know, between 20,000, which is their own acknowledgement, up to as many as 200,000 non-combatant civilians all throughout Southeast Asia, funded by heroin money that they were doing in partnership. The CIA station chief, Theodore Shackley, in partnership with Vang Pao, one of the major Laotian warlords. You know, and so we got to expose this stuff. That nobody conceived of being able to expose that type of heinous activity on the part of the United States government and getting a court to actually rule in our favor on that. But we did do that. And then I was recruited to go to F. Lee Bailey's office, the number one criminal defense firm in the country at the time. I was asked to come in to be at the firm, and we ended up, I was coming in to actually represent F. Lee Bailey, who was the senior partner there that had been indicted on this matter down in Florida. So I was brought in to be the third trial attorney, and we were there, and then the Watergate burglary happens. And so we get retained to represent James McCord, who was the CIA wiretapping specialist who was caught inside the Watergate Hotel and is the one that we ended up getting to blow the whistle on Richard Nixon and the plumbers unit. And so I kept finding myself in these rather extraordinary places, but I was constantly confronted inside the Cahill firm with them wanting me to do really inappropriate things They wanted me to. They represented the A&P, the Great Atlantic and Pacific Tea Company. That's a big grocery chain. And they were engaged in discriminatory pricing inside the ghetto areas in the cities, charging up to 20% more on items because they knew that the people didn't engage in comparative shopping. And so when a demonstration broke out against them, they wanted me to go and get an injunction against them. The senior partner saying, because people like that. That was people like that. There was Operation Breadbasket with Jesse Jackson and the people out of Chicago were running the demonstrations. And so I refused to do it. And I refused to do a number of other things that they asked me to do. And so I ended up leaving the firm and going to Lee Bailey's office. So I was there when we were doing the Watergate burglary. And then I began to discover a lot of other things. That I discovered that, in fact, F. Lee Bailey was on Index 4, which was a list of 4 prominent criminal defense attorneys here in the United States who were to be contacted by any CIA agent if they were caught engaged in domestic covert operations. Now, that might not sound as shocking to you as it did to me, but it's absolutely forbidden for the CIA to engage in domestic covert operations in the National Security Act of 1947. Absolutely forbidden from doing this. And yet the Central Intelligence Agency had gone all the way to the point of having a secret list of attorneys to be hired by the CIA people when and if they were caught engaged in a covert operation inside the United States. And so I was a bit taken back by that. And then I discovered that F. Lee Bailey, in addition to being on Index 4, he had, when the Watergate burglary took place, we discovered that of the 4 people that were arrested inside the Watergate Hotel, 3 of them were anti-Castro Miami-based Cubans, and that all 3 of them used to be gunmen for Santos Trafficante, who was the head of the Mafia Don in Havana. And much to my surprise, it turns out that F. Lee Bailey was the lawyer for Santos Trafficante. And so he had contacted Santos Trafficante to explain to our firm why 3 of his gunmen were in the Watergate Hotel burglarizing the headquarters of the Democratic National Committee and putting wiretaps on Larry O'Brien's phones. And turns out Santos Trafficante told us an interesting explanation. And it turns out that the reason that they had gone in is because they'd been ordered to do so by Richard Nixon himself, personally. He had ordered them to go in to burglarize the place and put wiretaps on Larry O'Brien's phones because Larry O'Brien, immediately prior to being designated as the head of the Democratic National Committee, had in fact for 20 years been the chief lobbyist in Washington, D.C. for Howard Hughes. And it turns out that Howard Hughes is the guy that Richard Nixon, now the President of the United States in 1972, getting ready to run again for his second term in 1972, when he had been the Vice President of the United States under Dwight D. Eisenhower from 1952 to 1960, he had, in June of 1960, contacted Howard Hughes, who was a secret consultant to the National Security Council in the White House. Hughes had been secretly designing the Glomar Explorer. It was this special craft that could reach down and take up submarines off the bottom of the ocean and a number of other things. That Richard Nixon had contacted him and asked him to put together a political assassination team to assassinate Fidel Castro and Raul Castro and Che Guevara and the 5 other comandantes of the new Cuban revolutionary government. And it turns out that, oh, by the way, these are the people that killed President Kennedy in Dallas in November of 1963. And Richard Nixon was terrified that if, in fact, it was exposed that Larry O'Brien, who was the Washington counsel for Howard Hughes, who had put together the team, would have known about it. And that therefore this guy, O'Brien, might actually use this information against Richard Nixon and stop him from being reelected in 1972. Now, you notice what I said there. You probably have a little bit of a reaction, more than just one person. Other than that, Mrs. Lincoln, how did you like the play? That yes, Santos Trafficani told us in detail about the assassination and how it had gone down and who had done it, and that it was the team that he had actually assembled at the request of Howard Hughes to put together the assassination team to kill Fidel Castro and Raul and Che Guevara and the others, and that this team had done a 180-degree turn and had killed the president because the president had betrayed them and had backed out of overthrowing Castro after the Cuban Missile Crisis in October of 1962, when we had just come to the very brink of absolute total thermonuclear destruction of the world over Cuba. And so I was a bit stunned by this information, that not only that it had happened, but that Lee Bailey knew about it, and that he was working with the CIA, and that the CIA knew about it, and that not only the CIA knew about it, but that in fact the Warren Commission knew about it, and that they were all concealing it. And so here I was again discovering now, at the age of 30, I guess by this time, what was really going on in the world. And so I had this major throwdown with Lee Bailey after I'd been asked to go out to represent the American Civil Liberties Union at Wounded Knee, the big occupation at Wounded Knee in 1973. And when I came back from that, Lee called me into his office and he said, Danny, I understand you were out at the occupation at Wounded Knee out in South Dakota. And I said, yes, I was. And he said, well, which side were you on? So I explained to him that we were working as amicus to the court, providing constitutional law briefs and stuff on, and we were helping to negotiate with the FBI to get medical supplies and food and water brought into the people that were in the compound. And he said, what the hell good does that do us? He said, if you've been working with the Justice Department to help them, at least you could have earned some goodwill so you could go in and help negotiate a better deal for maybe the Angiulo brothers that run the mafia on the north end here of Boston. And I'm just saying to myself, what am I doing in the office with this person? And he started going into this big rant about how it wasn't our responsibility to make any kind of ethical judgments about the conduct of our clients, that it was our job to construct the best possible defense that we could for what it is they were doing. It wasn't our job to try to stop them from doing what they were doing. I mean, it was like a reverse lecture in Judeo-Christian social ethics. And so I was offended by it. And I remember that following Sunday morning, after Mass, I stopped by this bookstore, and I was kind of wandering around looking through the bookstore, and I came across a copy of A Theory of Justice by John Rawls, who was the chairman of the Department of Philosophy at Harvard University. And I started leafing through this, and it turns out that he was writing a major book about the basic theory of justice that he thought undergirded the entire justice system in Western civilization. And he thought that he was going to be writing a major work about majoritarian utilitarianism, thinking that when a given culture that is a democracy is confronted by a particular public policy problem, they will select that option to address that problem that provides the greatest good for the greatest number. Seems like a perfectly logical mode of ethical reasoning for a democratic society. And he thought that that's what would be reflected upon his study of this. But he discovered that that wasn't true. That in fact, rather than our society selecting the option that generated simply the greatest good for the greatest number, it would select the different option that generated the greatest good for the greatest number, which still would provide at least something for the least well-off, he discovered. And that he discerned that this alteration, this selection of a different solution or response to the public policy problem was the result of the existence of another philosophical school of thought other than utilitarianism. And it was what he referred to as the Intuitionists. And I said to myself, look at that. There they are again. Here's the Intuitionists. Here's what was referred to in those other articles as the Intuitionists that were the source of natural law philosophy. They would say things like all men are created equal and endowed by their Creator with inalienable rights. And they go on, and they make all of these kind of apodictic statements about metaphysical reality and moral principles. But here it was. He was asserting that this community, within the philosophical community, actually had the effect of conditioning otherwise way over crude, simple utilitarian, majoritarian decisions. So, for example, he puts forth the hypothetical that if in fact they were following just raw majoritarian utilitarianism, why is it that the 90% of the people that are white don't still own the 10% of the people that are black? Because it offends some basic intuitional premise on the part of the Intuitionists, who basically counter that utilitarian solution with the other option, that one does at least something at least for the least well off. And so what they do is they what? They free the slaves, which is sort of minimal response, but you don't have to go give them rights or let them vote or marry white people or anything like that, but you at least have to free them. And so he started to list out some examples of the kind of effect that the Intuitionists had upon the otherwise raw majority of making decisions that were to their self-interest. And so I saw this book and I said, wow, this is really far out. Maybe I'm an Intuitionist of some sort. And that's what's causing me to have these arguments with the people inside the law firms. And so I called up on the phone on Monday and wagged my school tie at his secretary. Said, my name is Danny Sheehan. I graduated from Harvard College and I had graduated from Harvard Law School and I did the Pentagon Papers and did blah, blah, I was doing this. I said, I'd like to be able to talk with Professor Rawls for about maybe 15 minutes if I could. So she sets up an appointment for me. He agrees to do it. And I go over to sit down with him. And the 15 minutes turned into 45 minutes and turned into an hour, turned into 2 hours. And he ended up asking me to come back, to leave the Bailey firm and come back to Harvard to do a PhD on comparing and contrasting utilitarianism with Intuitionism. And so I wanted to leave Bailey's shop anyhow, and so I said, great, that's what I'll do. So I ended up going back to Harvard University and enrolled there in the graduate program. But much to my surprise, I thought I was going to end up in the philosophy department studying under John Rawls, but it turns out that they enrolled me over at the Harvard Divinity School because Dr. Ralph Potter, who was the professor of comparative social ethics at Harvard University, was based over at Harvard Divinity School, where he taught Judeo-Christian social ethics. So I end up getting enrolled at the Harvard Divinity School, and so I start studying this entire issue about natural law and intuitional experience, and ended up being there for 2 years, working at the master's program, then rolled it over into the PhD program, but ended up getting recruited from there to become chief counsel for the United States Jesuit Order in Washington, D.C. And so they asked me to interrupt my studies between the master's work and the PhD work and to come to work for the Jesuit National Headquarters in Washington, D.C., and that's where I went. But what I want to do is when we get together on Tuesday, what I want to do is I want to start to explain to you in detail what it is that I discovered at the graduate level in the studies at Harvard about this whole issue of intuitionism and natural law philosophy and what it was that was taught to the people there at Harvard about what the source of these values are and what the kind of metaphysical thinking is that goes on to support natural law. so that when you read these things that I've asked you to read, the first one of which, as I've suggested, is a little bit opaque, but it states very flatly just exactly what the major law professors and people talk about of natural law in law schools. But you can't tell where the there is. You can't tell, where's the beef. You don't know how it functions operationally at all. And so that will direct you to the other two assignments that I asked you to read, which is the section, the 3-page section on natural law. And you can read that, if you would, the other 3-page piece, which is the one on naturalism, the philosophical ideas of nature. And you'll start to get a sense of what it is that we're talking about here. But I want to move in on Tuesday to actually explaining to you what the core beliefs are of natural law philosophy, where they come from, what the sources of them are, and how this particular worldview relates to the rest of the worldviews that occupy the octave of human worldviews, that range all the way from the authoritarian worldview on the far right to the reactionary worldview, to the conservative worldview, to the moderate worldview, to the liberal worldview, to the progressive worldview, and the utopianist worldview. That these are going to be the worldviews that we talk about in the class here, because I'm going to point out to you that, in fact, every single one of these worldviews is arguably just as legitimate as each of the others. And that poses a problem that has devolved into this concept of postmodernism. That, in fact, the postmodernists are saying, well, look, you can't tell that any one of these things is absolutely true, and so therefore one's just as good as the other. And so you fall into this realm of sort of aimless relativism. You've got your opinion, I've got mine. A particular person may be attracted to 3-year-olds, and I don't think that's a good idea. But you can't really explain definitively why they shouldn't, other than from some kind of utilitarian thing that's a really bad idea, it's mean to people, And so that what I want to do is I want to start to discuss with you these alternative worldviews and juxtapose this to the whole issue of postmodernism, which is the basic boogeyman that you're going to have to deal with, of all these exponents of postmodernism. In the fact that, if you're really an intelligent, well-educated person, you have to embrace postmodernism. And I'm going to show you why that isn't true. Okay? And so we'll start that discussion on Tuesday, but we're at the spot for questions now, and I've said that 2 or 3 of you have already raised your hand for some questions, and I want to answer any questions we got for the next 15 minutes, and then we'll have to go back over to Porter for our section, because people are going to come flooding in here. Okay? So that we've got one of the fellows that had his hand up is gone. But anyway, this is difficult. I know there's always this abrupt ending, and then you have to try to figure out what questions you've got. But whatever questions you might have, let's talk about them now, or ideas or observations that you'd like to make. Okay. Yes. Sophia. It'd be difficult not to do. You can still ask it.
Okay.
No.
I've read Rawls, and so Rawls he can't be purely intuitionist, is he? Because he does propose a logical test for the goodness or justness of a society or its actions. It's called the veil of ignorance. I'm sure some of you others in the class have also read Rawls, but basically the idea is that if you get placed in, is that would you agree to live in a society that did X if you didn't know who you were going to be in that society? You could wake up in a mansion or on a park bench and you don't know. I'm curious as to how this relates to intuitionism.
Well, it's what he thinks is sort of a compromise between raw utilitarianism and this intuitionism. And he talks about the two of them. And you'll see that for a whole half of the book of A Theory of Justice, it's his endeavor to rationalize and justify this contractual theory that he sets forth. But you'll notice in several places he makes reference to the fact that, well, there's a whole set of arguments that are much more sophisticated and complex relating to intuitionism, which I'm not going to deal with here. And I'm going to deal with intuitionism as the one where you can discern principles by way of simple reason, logical reason. And what all those are echoes, all those little references that he makes are echoes of a footnote that he drops in his PhD thesis at the University of Chicago, where he says that, look, the bottom line is my analysis of distributive justice is completely materialist. It doesn't take into account any of the higher values of spiritual evolution, happiness, beauty, any of these other virtues, the kind like they talk about in ancient Greece or the Stoics or anybody else. This is a strictly materialist analysis, and therefore, I don't want you thinking it's going to be any more sophisticated. And he's right. It's not any more sophisticated than that. And so what he tries to offer, he's offering up what he thinks is a completely rational, logical, materialistically grounded mode of ethical reasoning. But in fact, as Nussbaum, for example, Marshall Nussbaum criticizes him from the University of Chicago, saying this doesn't account at all for how you deal with people who, in fact, don't contribute anything to the culture at all. What about a person that's born deaf and dumb and blind? Or a person who's a complete orphan and has no one to take care of her or him? That pursuant to his mode of ethical reasoning, it doesn't explain why in the world anybody would do anything for such a person. And that's what the fundamental problem with it is. And so my argument is that it falls prey to the same basic criticism that he lodges against utilitarianism. It is basically heartless and soulless. And in fact, I'll have to get that fixed before next class. So that's the problem with it. So how it relates to them is that he pretends that it's kind of a happy medium between utilitarianism and intuitionism, but it's not. It's simply another form of majoritarian utilitarianism. But what he really points out is that he thinks it's the best he can get away with, given the fact that the people who are making all the decisions, which is what this course is all about, of who these people are, the secret government, these people behind the scenes that are making all these decisions, like who greenlighted the assassination of President Kennedy. Who did that? And why did they do that? And how did they get away with it? How come nobody's exposing them? That whole issue, he's trying to talk to those people. And he's trying to get them to agree to give up as much as he can get them to voluntarily give up out of their entrepreneurial riches. And he talks about it at some length. And Marshall Nussbaum criticizes him for exactly that. Okay? So that's yes.
Well, you can tell me,
but that was a good question. That's a good question, Sophia.
You can tell me if this belongs to some discussion section right now. I was just wondering when you were talking about the Pentagon Papers, when you got the decision, before that, did the judges read the Pentagon Papers, or were you guys mostly just trying to figure out if you get the right to? Did they know what they were getting themselves into exactly?
That's far out. That's a really fundamental question. It was the operative key question that functioned at the core of the decision of the Pentagon Papers. And we can discuss it over there because it's a little lengthy. But there's a whole section of the book that I wrote. It's called the People's Advocate. There's a whole 15-page section of the book that talks about the details of this dynamic that went on inside the office, about whether or not we should allow the judge to see them, because we had a copy of the papers, and when we went into chambers with Judge Gerfine, sat down and he said, "Okay, gentlemen," he said, "look, let's get something out of the way here right away. Let's get Mr. Abrams here from the Cahill firm to acknowledge that you've got a copy. You've got a copy of the Pentagon Papers, right? You admit that, right?" And Floyd Abrams started to go, well, yeah. I said, excuse me, hold it. I said, this is basically like being in a police interrogation. You don't do that. And I said, Your Honor, you are free to make any kind of assumptions you'd like, but we don't acknowledge at all that we're in possession of the Pentagon Papers. And he said, what do you mean, Now he said, what about the New York Times has them, he says. And I said, well, one could draw that inference. But we're not acknowledging it. If you want the burden of proof on that, the movements on this restraining order are right here. Here's what's his name? Whitney North. What was that? Is right here, and have him prove it to you. And Murray Gerfine went, gee, can't we even get a basic agreement on something like that? And I said, I don't think you quite understand the gravity of the question you're asking here. Because if you start asking that question, you're going to say, how did you get them? And did you have any right to keep them? You're going to go on to a whole long thing like that. I said, so, let's just get started from here. And they're the movements, what are you asking us questions for? They're the ones that want to get the restraining order. So if you want, you can bet they've got a copy of them. You can bet they've got a copy of them. So ask them. And so he said to them, to Whitney Miller Seymour, he said, okay, Mr. Seymour, would you be willing to provide a copy of the 47 volumes to the court? At which point Whitney Miller Seymour said, absolutely not. He said, the court doesn't have the proper security clearances to have them. And so I said, great. Are we done now? Can we leave now? Are we ready to go? And that, so that we'll have a further discussion about it in the section. Okay. No, let's get the student. Let's get the students that are asking. I've got questions. I know you got a bunch, right? Come on, kids. Don't disappoint me. We're on television. Okay. Yes.
I'm sorry. Could you just really quickly redefine utilitarianism?
Yes.
And then, is it inherently in opposition to Intuitionism?
Okay. Utilitarianism is a mode of ethical reasoning pursuant to which an individual or a collective community is confronted by a particular challenge. And what they do is when they review the range of potential responses they could have to that challenge, they select that option that will generate the greatest good for the greatest number. Now, you can start out at the base level that Rawls did of saying, well, let's confine that just to your materialist interests, okay? That your share of whatever the common commodities are, or your share of anything else that's the community has to offer in a strictly materialist sense. But you're right, somebody in the community could say, well, when it comes to what the greatest good for the greatest number is, I happen to think that it would be good for me to feel good about giving this poor blind person a share that the least they can survive on. I find that to be part of the good. And so then what you'd have to do is find out how many people in the community agreed with that. And if a majority of them didn't agree with it, it doesn't become operational. So what becomes operational is usually that which the majority of the people in the community find to be of direct material benefit to them. And then they work up from there. And you start to see, well, can you supplement that with any kind of a consideration on the part of a majority that has something other than simple material benefit? And that's what Rawls is engaged in. Rawls is engaged in trying to supplement that community sense of having some additional values that they take into account. First, he argues from a strictly utilitarian point of view, the classic thing that, if you don't do this for people, people are going to think you're really bad people and that they won't trust you, they won't give you implicit trust. And so he makes a bunch of different arguments like that, but they all come back to basically being utilitarian. Is this useful for you? So the answer is yes, but it doesn't have an awful lot of operational effect because for the most part, it's difficult to get the majority, or more pointedly, to get the representatives of the majority to acknowledge that there are these additional values so that you can get a majority vote on that. So the answer is yes, but. Are there any other students? Okay.
Really, I'm trying to think of how to phrase this so that it sounds better than I think it might come out, but it's just kind of astounding when you talk about where you were in Harvard and that you started waging these cases using the Constitution to defend basically truthfulness instead of just a whole,
Yeah.
Yes. Mountain full of lies. My first and real question is, what was happening in the country before that? Was there a significant history and body of law of people who were really exercising, let's say, our natural law rights to not just be completely governed by those who were de facto in power and had money?
So let me give you the short answer, because then we have to get time to go over next door. Okay, the answer is that there was another period where there was a very aggressive activity on the part of people pushing back against these robber barons, and it was during a period from 1874 to about 1920, and it was a period in which there was an operation called the Chautauqua Movement. It was begun by the Board of Homeland Ministries of the United Methodist Church, and they set up they had a big summer camp up on Lake Chautauqua, up in northern New York, up by Niagara Falls, and they invited all of the people from across the country that were going to be Sunday school teachers in Methodist churches to come there for the summer, and they could bring their families with them. They could stay for the whole summer for free, and they would be trained. And one of the major principles they were attempting to train them to understand is how contrary to Christian social ethics the conduct of the robber barons was, that owned these big factories that were having everybody work for pennies a day, and making them live in community, in country stores, and not giving them any health benefits, and firing them if they got injured, and the whole panoply of things that were going on during that robber baron era. And they were training first their Sunday school teachers to teach their young kids in the schools, in the churches across the country, how antithetical those kind of policies were to classic Judeo-Christian social ethics. And then what happened is that that went on for like 4 years, from 1874 to 1878. And then they got the great idea of saying, look, why don't we open these classes that we're having up here in the summertime to all of the social studies teachers in the schools across the country? And what happened in 1888 is you had your thousands and thousands of high school social studies teachers flooded to Chautauqua, New York, and they overflooded the facilities. And they had to set up tents and get people from all around the area to bring food in, and so that they had this extraordinary event that was very much like, what was the big concert? Woodstock. That's it. It was a precursor to Woodstock. And they had thousands and thousands of people camped out all over the hills and everywhere, and it rained on them, and the mud came down, just like it happened at Woodstock. And there were all kinds of people from around the state came in and brought them food, and then they all went back to their high schools and started teaching this stuff. And then the following year, they had regional Chautauquas. And it turns out that by 1920, there were 2,300 Chautauquas that were held locally all around the country. And they were moving aggressively to condemn the activities of the industrialists and the robber barons and the corrupt politicians that were being bought off by them. And that whole movement was also supported by major litigation that was undertaken by them in the courts to try to stave off and stop what these people were doing. And they moved into the legislatures and started to threaten to throw people out of the legislatures that wouldn't support legislation. And this movement, the Chautauqua movement, is what generated the women's suffrage movement. In 1919, ended up setting up the 19th Amendment. They initiated the American Labor Union movement. They generated the American public school systems. They generated the conservation movement in the country, and they generated the post-Civil War civil rights movement throughout the entire country. It all came out of the Chautauqua movement that went on during that period of time. And the reason that it got choked off before it became fully effective was because of the Bolshevik Revolution in 1917 and the rise of antipodal global communism opposing the ethic of the robber barons, this Caucasian nation-state-based corporate capitalist imperialism, which is the operating thesis of the 19th century imperialists. Okay, so let's get over next door. I don't see anybody flooding in here. If it turns out they weren't telling us the truth, we might get to stay here next time. But I'm assuming there's a big line outside.